Today is July 26th of 2024, and we welcome you to our Chapter 49 podcast. Chapter 49 represents most IRS employees in the state of Indiana. My name's Larry Lannon. I'm a volunteer in the area of communications for Chapter 49 and a volunteer and retiree, which is how I get the time to do this. And of course, our chapter president, Duncan Giles, takes time out of his busy day to join us on these podcasts. Duncan, welcome back.
Thanks, Larry. It's always good to be here.
And we'll bring our guest in just a moment. But Duncan, we do want to remind people we will be taking a week off. We do this occasionally, but we'll not be recording a podcast next week in case, people meticulously put their schedules together to listen or watch this podcast.
If they do it, I'd be very worried if they're that strict about it. But yeah, I will be taking some, actually my beautiful wife, Kim, and wonderful daughter and son-in-law and grandson need some time off. So we're taking a week off and doing some fun stuff.
Well, good for you. Hope you enjoy your time. And our guest, if you're watching on video, you can see that. Welcome back to our podcast. He's been a guest many times before, always informative. We enjoy talking to him. Dan Kaspar for the NTEU National Office. Dan, welcome back to the podcast.
Thank you so much, Duncan and Larry. And I do set my clock every Friday to that podcast, so I've got some free time next week.
Okay. I am so worried about you.
Well, let us get to our serious subjects. We have a number of them to discuss with Dan, and I'm going to let Duncan ask the first question.
Yeah, Dan. This week, matter of fact, just a few days ago, OPM came out with a very good decision, I believe, for employees that NTEU had been pushing for quite a while, having to do with higher graded duties issues. Can you talk about what that decision was and what it means to our employees?
Absolutely. 20 years in the making, which that 20 years has become a magical number somewhat. If you'll recall, it took us about 20 years for paid parental leave to get that through finally. Yeah. So, the higher graded duties, and I should just explain what that is, very briefly. As you know, in the federal government, a temporary promotion, if it's going to be beyond 120 days, it's got to be done through competition. However, we've seen this, and I know you've both probably seen this come up, quite a few times, and it happens in other agencies as well, where an employee, let's just say to grade 7, ends up doing more work, over 25% of their work on what's called direct time at a higher grade level. And, for decades, NTEU's filed grievances on behalf of those employees saying, wait a second, these folks should be paid at the higher grade level, at least the difference between what their current grade is and this work that they've been doing for more than 25% of their time. So that's what's known as higher graded duties grievances. And over the years, up until 2004, we were able to, when successful, get those employees a full remedy. The difference for that full year, if they'd been doing it for 2 years, the difference between their current grade and the higher grade for full 2 years. Well, in 2004, there was a decision that came out through the Federal Labor Relations Authority that said because higher or temporary promotions can only be done over 120 days with competition, even though the employee was forced to do these higher graded duties for 1 or 2, however many years, the remedy is limited only to 120 days. Very unfair decision, but it's been the law for 20 years. We have tried to get that decision overturned at the FLRA through the Field Operations Department at NTEU through arbitrations. We've tried to get it overturned through what's known as a negotiability appeal through our negotiations department. Well, here, our Office of General Counsel, working with us, filed a petition at OPM to say, OPM, you need to change this regulation so that there is an exception to that rule, where if through a settlement or through a decision by what's called an appropriate authority, like an arbitrator, says that the employee was forced to do higher graded duties in violation of the contract, that employee gets the full remedy. And so OPM just this week, they agreed with us, and in a final rule after public comment, they changed the regulation and employees will now get full back pay remedy in those kinds of cases. Wonderful, wonderful win.
And this is just for going forward. We're not going to be able to do cases back, like 2 or 3 years ago. I already had employees emailing me about that. Can we go back and do that? Love to, but unfortunately, it's not retroactive.
That's correct, with one small caveat. So the rule will actually go into effect on August 26th. Whenever OPM issues a final rule, it's 30 days from the date of that final rule when it goes into effect. Grievances, if they have something that says, to the full extent of the law for the remedy, whatever that may be, we're at least going to have an argument if we take it to arbitration that if it says to the full extent of the law, the remedy has the farthest possible, reach that it could, we may be able to argue for that. So you're correct. We can't go back and file grievances now, but if we previously filed grievances, we may have some room there. We'll have to see.
Okay, and I think another thing that's pretty important for people to note here, one of the great advantages of this in the past, and we were both around when they did do this for the full year or two, is the fact that this can go now as if you're looking for another job, if you're a grade 11 but you've been doing grade 12 work for a year or whatever it is, and you get that grievance filed, now you'll qualify for those grade 13 jobs. Because I had that very circumstance, about 20 years ago before it came in, and was able to win that and get that that person the higher grade, skipping basically a grade because they had that for this. So I think that's an important part in this as well.
Absolutely. Yep. It's been built up over, chapters giving us great information to be helpful, in this. Our Office of General Counsel did an excellent job putting in the petition to get this kickstarted. And it's been a team effort, as I said, 2 decades in the making.
Dan, if I can ask a follow-up on this, there's always been a balance, and I've dealt with this law many years ago, so this gone back and forth, the rules that we go by. There's always been a balance, but NTEU's tried to do on this, because we do want people to get the opportunity to be able to advance themselves and maybe temporarily do higher graded work in order to make themselves more marketable for a promotion. Do you think we came out well in that balance, the way things have turned out?
That is an excellent question. It was actually something in dealing and discussing this issue with OPM that came up a bit. Article 16 of the IRS contract, for instance, it talks about details and temporary promotions. And if the agency does things correctly, consistent with the regulations, there would not be temporary promotions over 120 days unless done competitively. That allows, to your point, Larry, if they follow the contract appropriately, to get different people in after those 120-day periods. So this problem that was fixed through the OPM, rule is when IRS doesn't follow the contract and doesn't follow the law, appropriately. But the point of the detail of Article 16 is certainly if IRS follows that, it would give multiple opportunities to multiple people. Absolutely.
Going back to 1988, when I began as an NTEU steward, higher graded duties has been an issue ever since I started. It was always a topic of conversations anytime our local stewards got together. So this is a very important issue. Duncan, anything you want to add or ask before we move on to the next issue?
No, I just want our listeners and viewers to recognize that, this was in large part to NTEU. We really pushed this at the national level, had been having a lot of conversations over the years, as Dan outlined in different forums. And I'm just glad that OPM finally saw the light on this. And I just want to give all the credit in the world to NTEU National for getting this pushed through, that I think is a great common sense reg.
Let me move on to telework, because telework, we brought this up, Duncan and I did, we had Doreen Greenwald on this podcast just a few weeks ago. And I still think there's a great deal of angst amongst people in the workplace, because we've had what we first called FlexiPlace, and when the technology advanced, telework. It's the same kind of concept that started in the mid-90s nationally with NTEU. And I think there are people who see these attacks on telework from the Congress, from other pressure groups, people criticizing it, demanding that federal employees come into the office like every day. I'm curious, as far as NTU is concerned, has telework been working? We'll start with the IRS, and you can also talk about other agencies if you've had issues there. Is the IRS working well with NTEU to make sure our contract is being implemented and that people are getting the opportunities to do the telework to which they're entitled under our contract?
Yeah, I mean, it almost depends on the level of IRS, too. It's a great question. I've got to say, for the most part, at the top executive levels, and I'm talking about the commissioner, to the heads of the BODs and some of the senior leadership, even if they didn't get it before a couple of years ago, they got it now. And I think Commissioner Werfel's probably helped some of them, the holdouts, to get it. They understand the value of it, the intrinsic value of it, from a recruitment and retention, standpoint. They've seen people leave and cite lack of telework opportunities as a reason for leaving. They've seen people come in who have said, I've heard that the IRS, or at least in certain areas, this is a great place, for either remote work opportunity, telework, whatever it may be. And so it is a unequivocal success in terms of having an expanded telework, remote work option for the IRS. Where we've had more struggles, in my view, is at some of the lower levels with kind of holdout managers, where we've seen things like come in to the office on this day to hold meetings, and then everyone goes into their office on Teams with the door shut to have said meeting, which makes absolutely no sense whatsoever. Yet it's an anecdote that I hear almost everywhere I go and every time I talk with somebody. So part of that is they're not getting sufficient guidance from what I would say is the mid-level, managers, on this, who ought to be saying, this makes no sense whatsoever. It's not a business need to have people come in for the scenario that I just gave. So the support is there at the top. Often they need to do a better job of trickling that down the many levels of management in various areas of the IRS. But they understand it. They're up against some of those stakeholders, Congress, frankly, mayors of large cities that are concerned about commercial real estate, but they're working within that area as best as they can, and we're trying to push them to keep them honest in that area.
Yeah, I did see there was a study done, and the Congress keeps saying we need data. We need data. Well, the latest study I saw was at the U.S. Attorney's offices and the Department of Justice. You may have seen this, and it was very clear that it had two major impacts. At number one, the attorneys and the support people were leaving these U.S. Attorney's offices for places where they had telework opportunities, as far as just retention, and of course, making recruitment available. People were more easily recruited if there was at least some, and people aren't necessarily wanting to telework every day or even all the time. If you can give them 2 days a week, for example, that tends to satisfy most people. So do you think we'll see more data to convince people like the Congress that this just might be a good idea?
I do. Sometimes gauging productivity, depending on the job and the agency, is not the easiest data to gather. So we will see more of those just through congressional requirements, I think, going forward. But the data is unquestionably clear, and there was a Treasury study not so long ago that came out, to this effect, that shows the number of applicants that they get for positions that are designated as telework, remote work eligible, for instance, versus those that are not. Similarly, in exit interviews, to the extent that agencies do these and do them, half decently, there's significant data. That is, if not the number one, it's in the top 3 reasons someone cites for going from one agency to another. There isn't just one agency, as you both know, in the federal government. There are other options aside from other employers for these folks to go to. In my view, the train has left the station, on the telework question. This is what employees want. There was in many ways, involuntary pilot that happened during the pandemic, where we saw that this could work. Folks saw how this could improve their lives. And, some of the agencies are getting it, some aren't, but, we're collectively going to be fighting, for them to get the maximum work flexibility that they possibly need.
Anything you'd like to add or ask on telework, Duncan?
The thing I'd like to add is that folks who are worried about this, we do have a contract. The contract is there for 3 more years. And so, these rules are going to remain in effect at the IRS. Different agencies that NTEU represents go through contracts at different times, but for the IRS right now, our contract is sitting there. It spells out who can take it, when we can take it, how much you can take. And there may be some in Congress, some in the IRS and other places that may not like it, but that's where it stands and that's where it's going to stand. And I would make a very sizable bet that at the next bargaining table, we're going to be pushing to have at least as much, if not expand our telework opportunities. Would you say that's a good assessment, Dan?
Absolutely. And it would benefit the agencies too and the federal government by saving real estate, costs as well. So.
Okay, Duncan, you have the next question.
Yeah, it's the middle of summer. It's hot weather. It's nice, but we're sitting there barreling towards October 1st. And Dan, just wanted to get your impression of what you're hearing on what's going to be happening with the budget situations, come October 1st, because again, that big bundle of money I'm willing to bet, I'm also willing to bet that we're not going to be able to get appropriations bills passed and signed by the October 1st date. So what are you hearing, and what are your thoughts on that?
I would not oppose your bet on there, Duncan. I think that's a safe one. So I had an occasion just recently to talk with our director of our legislation department, Kata Sabinga, and what she said to me was, to your point, Duncan, it's almost certain that they're going to need a continuing resolution to continue, have appropriations flowing at the current level. I hate to speculate too much, but it's probably, does this go through December or does it go further into the next year? The safer bet, more recently has been it's going to be a shorter term CR, just getting us into, December. Tough to tell, but I think that a continuing resolution is the most likely scenario here. And Larry alluded to the fact that, politicians don't want to shut the federal government down right before an election. Even as divided as politics have gotten right now, that's probably still a safe assessment here as well.
Yeah, I think it's what I've seen as an observer of politics, particularly in Washington, is that both parties' leaders in the House and Senate do not want a government shutdown right before the election. This is not good politics for anybody. And you will see individual members of Congress and the Senate clamor for a shutdown. But I think what I'm hearing you say, Dan, is your legislative department is saying there's no real stomach from most of those in Congress to do that.
Right. With every, potential caveat that we aren't always right about that, but, the best assessment now, absolutely. Yep.
Speaking of the Congress, the pay raise is still in question. President Biden has proposed a 2% average increase for federal employees in 2025. The military is set to get 4.5% based upon that recommendation. Final decision is up to Congress. Where are we on that issue?
Well, we were not pleased at all, that the president's budget got away from the traditional pay parity there, and we certainly both publicly and privately have expressed the need for there to be parity. We continue to do that right now. A little harder to guess, to speculate on what will happen here. I think, from our legislative department, there's the prior budget deal, that was reached before that somewhat constricts the funds there. It's tough to tell, but we're going to keep pushing, to see if we can at least get that up to parity. Also supporting, the bills in, I know at least in the Senate, and I believe there's one now, or just in the Senate right now too, but to go above even what the military's percentage was. That exact percentage escapes me, but it's higher, up there around 7% or so, if I recall. Yeah.
Okay, I want to ask about something else, if I can. Well, how about you ask the next question? I don't want to leave you out here.
That's okay. Dan gives such great information. Doesn't matter whether you're asking the question or I am. We're just happy to do it. Dan, something that most employees are not aware of, and there may be a lot of chapter leaders who are unsure about this as well, is once you go through the grievance process, you go through the first step, maybe 2-step, maybe 3-step. Once that goes through and you can't reach an accommodation, an agreement, something of that nature, then it goes to possible arbitration. And can you talk a little bit about the decisions that either NTEU National or the field offices make, and what goes into going for something for arbitration, as opposed to saying, well, this might be a good case, but we're not going to take it to arbitration because.
Absolutely. This was actually something that I got an opportunity to talk about at our national training conferences, spring national training conferences, where we train chapter presidents and chapter leaders across the country this past spring. We have a standard when we look at cases for potential arbitration, which is a reasonable likelihood of success on the merits. Not a mathematical formula, there, but we try to take into account whatever the case file may look like. If it's a disciplinary action of some sort, if it's a contract violation of some sort, we work hand in hand with the chapters and the chapter stewards, chapter president, to evaluate that case. And we're looking at it both against the contract language and against prior precedent. We've talked about higher graded duties grievances earlier, here. After a while, when you do enough of those things, you win some, you lose some, you get an idea based on that precedent, what the current case is before you and what your chances are going to be there. So that's always, a major, aspect of it. There are other things too, like, the availability of witnesses and other factors, but really those are the big ones. Do we have a reasonable likelihood of finding success on the merits here? I'll tell you, when it is even or we're not exactly sure which one, the thumb's going down on the scale to take that case. We want to be a little aggressive, and that's what I've told our field offices, too. If you got an argument to make here, let's try to make that argument and give it our best shot. You can get a poor decision if you don't have a standard, like that. Sometimes, we've heard before, sometimes the fight itself is worth it. And that can be true in some respects. But if we don't have a standard, and if we take cases that we're quite certain that we're not going to win, not only does it not help the employee there, it could harm the entire bargaining unit going forward, because it could set bad precedent on an issue as well.
I think
as a follow-up to that, I'm sorry, Larry, let me ask this follow-up while I'm thinking about it. When we talk about the arbitration process from start to finish, we're talking about an individual's, not a national grievance or a mass grievance, but individuals, how long would you say those on average, and I know it varies, but on average, how long does it take? Because I've had to explain this to employees, and I'd like them to hear it from somebody who's dealt with this at the local and national level.
Absolutely. I mean, I think if I gave you the best average range, we're talking about 6 months to a year from the time of the invocation, of arbitration. Oftentimes, some of that wait time has to do with scheduling. We have panels of arbitrators, and those arbitrators, we're not the only cases that they're doing, of course. And we try to pick arbitrators who have an understanding of federal employee issues and who have dealt with the parties before, so they can develop a bit of an expertise when they're looking at some of these things. And we have some of the best arbitrators on our panels that are out there, and so you can imagine they're in high demand. So for some cases, removals, for instance, things that are more time sensitive, we try to push those up there as soon as we possibly can. Not every case is done within that time frame. Some may be earlier, some may be a little later, but that's a pretty good indicator of an average time span. Much faster than court, I'll say.
Well,
yeah.
Well, I tell you, that's not a great standard,
Yeah,
but it is still the arbitration
Yes.
process. And I should say that there's been a lot of arguments about arbitration in the private sector, for example. For instance, people follow the NFL. People complain about the arbitration process because the commissioner of the NFL has a final say. We go through an arbitration process where we have independent arbitrators make these decisions. And I think that's very important. Also, I'd like you just to talk a little more about something you already discussed. I think it's very important because when you make a decision as to when to arbitrate a case, you don't want to make bad case law, because you want to set a positive precedent for people coming after, so you can cite some of these decisions when trying to represent people in the future. You want to get decisions that are good for employees, not just now, but in the future.
Absolutely. And I'll give you a quick just IRS-based example, appraisal cases. In Article 12, there is a provision in the contract, Article 12, Section 4L, which is known as the counseling provision. It's been in there for quite some time. And it effectively says that, when there is a decrease in performance, at least according to management, the employee needs to be counseled, and not a pro forma counseling, but substantively counseled on how to bring that standard of performance back up again. That is something where if the manager does the good job and follows that, and shows the counseling, oftentimes we're not going to be able to take that case. And if we do, it's going to chip away at the effectiveness of Article 12, Section 4L. And that's going to harm employees across the country if we do that. On the other end, we take those quite often when the appropriate counseling hasn't been done, and we've been incredibly successful, at doing those there too. So, Larry, I know you're a former IRS manager, at least for some period, as well. So you're probably familiar with it from both ends of the spectrum of that article.
Well, fortunately, I never had anybody arbitrate anything I did, so that
Of course, we never.
I think I had one grievance filed against me, and it was a personnel issue, so I didn't have anything to do with that. I try to keep a good reputation as a manager. I want to ask one last thing, if I can, Dan. And there was a case before the Supreme Court. A decision was handed down. It was called the Chevron case. It received a lot of publicity, and it dealt with the authority of federal agencies, their legal authority to make decisions. I'm not going to get into the weeds. That just so you could talk, as lawyers can talk about that decision, and that there's still some question about what impact it's going to have on the agencies. My question to you is, do you think that decision will have any impact on employees working for IRS or really any of the other agencies represented by NTEU?
That is an excellent question. I will say also that, we all know that we have very smart chapter leaders at all of our agencies. And I'm reminded of that on a daily basis. And through this question, Larry, it's come up a number of times after that decision came out, overturning the Chevron deference. They've seen, at least identified the issue of the potential for that having an impact in here. Bureau of Land Management, EPA, I can name a number of agencies where they issue regulations on an ongoing basis that at minimum, we can say that certain industries that are regulated by these agencies are going to now form a new attack, or at least a revitalized attack. I think the IRS is probably in there as well. Now, you would think the IRS knows what it's doing and has the level of expertise when it is issuing tax-related regulations. Unquestionably, that is true. However, I think what this decision will do is you'll at least have people making a run at statutory language and saying to the courts, you no longer have to give such high level of deference over to the IRS when it is interpreting its own regulations here. It's tough for me to say the success level of that because it's probably dependent upon the agencies. But just as a corollary to this a bit, it's not just the federal agencies where our employees are employed. The Federal Labor Relations Authority, for instance, is going to have some of its rulings scrutinized a bit more in certain instances. That could be both helpful or harmful to what NTEU would like to see on behalf of employees. So not only will it impact their working conditions in terms of what their jobs are at these agencies for all of our employees, it's also going to impact some of the work in the future that NTEU does, where we are either able to argue that the FLRA's interpretation should not be deferred to, or vice versa.
What I always find interesting is that when I worked as a tax law specialist was that people complain about federal regulations all the time. yet the tax practitioner community would scream for regulations. IRS tell us what to do. I mean, they
Yes.
were never complaining about it. And as you know, Dan, many of the statutes that are passed by Congress talk about the secretary shall promulgate regulations because the Congress doesn't want to deal
Yep.
with details. Duncan, we're about out of time. Any question or comment for Dan before we wrap this up?
My last thing is, Dan, is there anything that we haven't covered that you would like to make sure that our listeners and viewers are aware of or know?
You know, I could keep us on here for a real long time with a number of things, but I think one of the most important things is, you know, I just want to go back to telework, just for a moment, and not even just about telework specifically, but over all of these wins and these gains that we have done with members fighting for these chapter leaders, us at NTU as well. You know, these are issues that are directly tied back, to who represents us in Congress, at the White House, and other, areas as far as that goes too. And that's going to be a very important reminder, just for everybody right now, because there are gains that, can turn around, in a heartbeat sometimes there too. So it's, I think, just something to remember, as we go away from this today.
I'll just have one quick comment if I can. One thing I learned in my many years of working, not just as a manager, but as a union official, talking to people inside and outside NTEU. NTEU was not the largest federal union, but we have a reputation for having the very best legal staff in the federal sector. So, Dan, I would count you as one of those attorneys at NTEU, always doing good work and always looking out for the membership and always looking out for federal employees and their best interests. And I have to applaud you and all the leadership and the Washington office and the field offices. I've dealt with all of you in my past work at NTEU as a chapter official, and I want to just let you know that there are those of us out here in the field that appreciate that.
Well, thank you very much. And you're right. I mean, every NTU employee here just, approaches this job every single day, just caring about the members who they represent. And we love nothing more than, working with the members and leaders like yourselves in this just collective action to try to make employees' lives better.
Last chance, Duncan, anything you want to add?
I think it's been very well summed up by Dan, so I'm good.
Okay, well, Dan, thank you so much. We always enjoy having you here on the podcast, and we hope you will come back and join us again. And best of luck to you and everybody working with you. This is the Chapter 49 podcast. I'm Larry Lannard. You are Duncan Giles and Dan Kaspar in this edition. So please be safe and be kind.